Hi guys, my name is Tyler Douglas. This is my presentation on tort liability. Let's talk about tort law. What is tort liability? The definition of tort liability is legal obligation of one party to a victim as a result of civil wrong or injury. This action requires some form of remedy from a court system, basically resulting in a court case, a trial. A tort liability arises because of a combination of directly violating a person's rights and the transgression of a public obligation causing damage or a private wrongdoing. In the sense of the educational environment, we look at tort liability, tort law as breach of duty or care, negligence in the form of willful or wanton conduct, or just traditional negligence of just you didn't properly prepare, protect, provide. It wasn't intentional. It wasn't as a result of budgetary constraints. It just occurred because you didn't think it was possible that it would happen. And that's one of the cases I discussed kind of along those lines. So, breach of duty, breach of care is in certain educational roles that our administrators have a duty of care to protect, secure, promote safe practices, secure the student's environment, basically be liable for the students. The first case I go over is Munn vs. Hotchkiss School. And basically, a student was bitten by a disease-bearing tick on a school-sponsored trip hiking through the mountains of China. The tick had encephalitis, a form of encephalitis that affected the student neurologically, and it prevented her from ever speaking again. The student's parents sued the school for negligence in two forms. One, not informing the parents of the potential of disease-bearing ticks, and two, not ensuring that students wore proper attire, used insect repellents, and the school didn't check them for ticks. So, reactive measures. First off, the school reacted by saying there's no way we could have known that there was a potential for disease-bearing ticks, as well as the likelihood for this accident to happen was severely unlikely, so they kind of overlooked it. Bing, 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 negligence. So proactive measures, waivers. For one, it would be incredibly important to waive liability for the school, but at the same time, the waiver could be used properly and inform the parents as well. Barrett versus USD 259. So a football player during a senior year collapsed on the field during a mandatory practice. This actually happened in Wichita, Kansas. The player died in the hospital the next day. The player's parents sued the school district. This was a mandatory practice, preseason, early morning, around 8:15. It was 83 degrees outside. The players were not full padded. They were just wearing their helmets, and they were permitted a 5-minute water break after every drill. The water could only adequately hydrate 11 players at a time. So over the course of this 5-minute water break, not everybody's guaranteed hydration, so on and so forth. After conditioning, the player fell to the ground, collapsed, was taken to the hospital. He died the next day. The parents sued the school district. There's really no other way to react to it than the way the school did. The school basically pled their case, saying like, "Hey, our coaches provided what we're required to provide as coaches for the students to maintain their safety." It's not reasonable to think that anyone would accept full responsibility, although playing the sympathetic role of the school to the parent that just lost their child, it was tough. I don't know if that kind of reaction is the right reaction. It may be the right from the sense of the school, but the morally right standard to just say that it's not your fault and not admit full responsibility right out of the gate kind of rubs me wrong. So schools and athletic coaches must properly understand the weather and climate, as well as understand the stress that their players' bodies go through when performing the drills and conditioning. And you see this a lot with the sport of wrestling, where coaches will not go on record encouraging their players or their wrestlers to cut weight. In fact, schools will put wrestlers to a position where they can ultimately say, no, you're done. Or the wrestler can be impacted by how much losing too much weight and becoming dangerously dehydrated. So that's an example of understanding the intensity of the sport and the stress that bodies go through, as well as the climate of the sport. At the same time, it'd be no different than canceling practice because it rains too hard. So those two have to work in correlation. Mitchell versus Cedar Rapids School District. So this one, it took me a while to actually get down to the details of the case where basically the core synopsis broke, but I was just reading, thinking like, okay, something to the degree of this student got hurt. This student, was out in the hallway, and because they were not being monitored correctly, tripped and fell, or this student was bullied and reacted to a point where, they had a fight and they hurt someone. No. This got dark. So two special education students, one each of the opposite sex, so a boy and a girl at varying ages. The boy was 19, the girl was 14. They developed some kind of relationship over the course of the year. The teachers in this situation, the IEP leaders for the Cedar Rapids School District that were over these two students, thought that due to the students' nature, that the age difference wasn't as big of a deal, and that ultimately what was transpiring was just they were relating very well because of their situations. The younger student has a recorded IQ of 67, and so that basically they were on the highest level, just being very friendly with each other. One day they both agreed to skip class and hang out outside of school, and the school was unable to identify that they were missing. While skipping school, didn't realize I had that in there twice. The older student raped the younger student, and there was actually a third special education student involved that just watched. So it got dark real quick. So reactive measures. The only acceptable reactive measure to accept this instance. The school made a horrendous mistake and had a huge breach of duty. So the school outlines in their aspect of all of this that basically they have policies in place for this particular program as well, that when a teacher marks a student absent at the beginning of the class period, it confirms with their parents via email. So it notifies their parents like, hey, your kid's not here. So especially in this case, this is increasingly particular because while we want to honor the independence of all students and trust that they can go to the hall, mingle with their classmates, and come to a class at the correct time, this particular student, in her case, developmentally disabled, that's inherent, and we put a lot of trust in educators and administrators in these particular roles, that they have special certifications to be able to work in this kind of environment, and that they will do their due diligence. Now, to what the court ultimately ruled, the breach of duty did occur. However, the school was under the defense that they cannot be held responsible for what happens just because their students left school. But that could be understood on maybe a typical student aspect, but due to the nature of this instance, these kinds of students need to have more dedicated resources allocated to them within the school to basically ensure that this kind of thing doesn't happen moving forward, and that is just such a kind of just dark instance that it shouldn't have occurred because of the nature of parties involved. So Barr versus Cunningham. A student was playing hockey in PE class. The student was struck in the eye by the puck, noted to be a safety ball after it bounced off the stick. The parents sued for willful and wanton conduct by not providing safety goggles. So reactive measures. This, on the other hands of the other three, seems to be one of the ones where not particularly the school's fault. More of a sue happy parent, if you will. So it'd be a safe bet to go ahead and purchase and provide safety goggles, because truly, if at any point in time it was the school's fault and it was willful and wanton conduct by not providing safety goggles, it's not like they had them and were told the students we're not going to wear them today, whatever. It's not like the students asked to wear them. They didn't purchase them because the supplies for the game, the plastic sticks with the safety foam balls, did not advise purchasing safety goggles within the same aspect. So to that degree, there had never been an instance before of the ball striking someone in the eye and causing permanent damage. The safety ball was designed to basically be safe. So this is more of the plaintiff and suing without backing. So in this particular case, the teacher even mentioned that that she didn't instruct them to wear safety goggles. In the future, I would instruct them to do so, even if it's just buying 30, a pack of 30 for the class and saying like, hey, wear these if you want to, or even if it came down to it, just all PE classes signing a waiver. My last one is Andreozzi versus the town of East Haven. So a student athlete was running during cross-country practice. The student was running on the track and ran into a bench placed in lane 1 of the track. When falling, the student injured his leg. The parents sued the school, saying the coach failed to uphold his duty of care for safety. So in this case, this was actually relevant in the sense of government agencies have immunity to these kind of things. So the school was not necessarily found not guilty, but was protected. It was interesting because the way this is worded, it almost seems like the student had an opportunity to avoid running into the bench, but at the same time, I didn't think it was going to go the route that it did. Ultimately, the court found in favor of the student, saying that the coach did breach the duty of care to protect the student athletes. So that was interesting to think that because the student chose, but then when you think about it from a legal standpoint, yeah, like it's the coach's job to eliminate the things that could be bringing harm to the student. So schools would not necessarily merit an extreme reaction to this kind of case. However, the coach should be disciplined to a degree. Like, hey, we need you to do your job. We need you to make sure the track is clean. So a plan should be put in place to ensure that the track is clear at all time, that there will be athletes running. So very simple proactive and reactive measures to that degree. But this has been my presentation on tort liability.